Case number 106-586, 106-587, State v. Dunn.
Good morning. I'm Rick Kittle. I represent the appellant, Mr. Dunn, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
In this case, Mr. Dunn was charged with and found guilty of stalking and forgery at a bench trial. And unless the court has specific questions about the facts, I'd move to the question regarding the adequacy of the complaint in this case, the first issue in the yellow brief. In case 09-CR333, the defendant was found guilty of forgery, and that count is set forth at page 5 of the yellow brief. On that page also is the statute of forgery, and I think it's clear, and I think the Court of Appeals also recognized that that count of forgery failed to contain one of the essential elements of the crime of forgery, intent to defraud. We are asserting here that that count was defective. We also, if this had been handled, it wasn't handled at a jury trial, but if it had been handled at a jury trial, the PIC instructions would have instructed that the jury had to find that the act that Mr. Dunn did was done without authority. That lack of authority language is also not set forth in count 8 of the amended complaint. So we think there are multiple problems with the language of count 8. Now the Court of Appeals here concluded that under the controlling law, you have to look at the four corners of the complaint to see if all of the essential elements of the crime of forgery might have been alleged somewhere therein. And so that's what they did. And I think it's important to go back to procedurally how this case happened in the district court. Count 8 is in an amended complaint. That amended, and that's the sole count in that complaint that Mr. Dunn was found guilty of, one count of forgery. That amended complaint initially had 12 different counts in it. Counts 1 through 8 were all charging forgery. Counts 1 through 4 charged one form of forgery, and they all included the words intent to defraud. Counts 5 through 8 charging forgery charged a different form of forgery, but none of those counts included the words intent to defraud. And what the Court of Appeals did is they went back to the complaint and they said, well, if you look at count 4 charges a different form of forgery, but it includes the words intent to defraud, and it's dealing with the same check number that's found in count 8. And therefore, we're going to basically amend or allow the language intent to defraud that's found in count 4 to supplement and fill in the gaps of what's missing in count 8. But what I think is remarkable about this case is the defendant was not bound over for trial on counts 1 through 7. We have a preliminary examination that takes place in, I think, December of 2009. And counts 1 through 7, they're done at that point because the court did not bind the defendant over on counts 1 through 7. So 7 or 8 months later, when the defendant goes to bench trial, he's only facing counts 8 through 12 and 9 through 12. 2 of those were dismissed by the state. 2 of them he was found not guilty. So it's just the one count of forgery remaining. But what has essentially happened here is that the Court of Appeals has added to what's missing in count 8 by taking language from a count that Mr. Dunn was not facing at trial. Now, it was in the amended complaint, but he hadn't been facing that charge for months prior to the time of his bench trial.
But isn't the issue notice of how to mount a defense? Isn't that at the heart of all of our jurisprudence on defective complaints?
Yes,
Does the defendant have notice? And so it's not really what they ended up having to seek at trial, or whether that count was still in play, count 4, It's what he learned from count 4 at the time he was charged.
Well, I guess I disagree with that. I think
Okay.
if you're going to use parts of a complaint to fill in the gaps for other counts, then the defendant at least ought to be facing charges on those other points that that the court is using to supplement what's missing in
I
another
understand
count.
that's your position, but he wasn't deprived of notice, was he?
Well, I think part of the reason we have this process of filing charges in a complaint is to adequately inform the defendant the charges he's facing, what it is that he's alleged specifically that he's done that has violated the law. And Hall talks about a common sense approach to all this. We're going to look at the four corners of.
But as I understand it, counts 1 through 4 were the made, altered, or endorsed, which is one alternative means of forgery, which we've said.
Right.
And the others are issued or delivered.
Right.
Which we've said uttered is an alternative means. So these are two separate alternative means. So it would be possible for a person to have made the check with intent to defraud, but perhaps didn't issue it or deliver it with the intent to defraud.
That's true, and I think that's an important consideration here because
Probably the other way around would be more logical, but
right.
the point being is they are alternative means.
They are. They're different. Well, let me go back to what I started to say about Hall. Hall talks about this common sense approach. To me, if part of this process is to adequately inform the defendant what he's charged with, if the defendant, in trying to figure out what he is charged with, has to say, if you take this element from this count and take some of the language from another count and you combine that with what's in another count, all of that taken together, cobbled together, I must be charged with forgery, I would argue that's not a common sense approach, because the other point is, and this goes to Justice Johnson, I think, the question and comments he made, if part of this process, again, is to adequately inform the defendant of what he's done that has violated the law, it just seems an incongruity. The way this was originally charged, it seems it was systematic in the way that the prosecutor charged this. He charged counts 1 through 4, including the language intent to defraud. That was one form of forgery. He charged counts 5 through 8, a different form of forgery, without the words intent to defraud. That to me seems systematic. It seems like the prosecutor's understanding of this was that certain forms of forgery do not have an intent to defraud as an essential element. I don't think that's correct, but if that's the prosecutor's understanding of the law, how can we expect a defendant to know that that understanding is not correct? We're asking the defendant to do too much here under this common sense approach to actually understand what he is being charged with, the specific nature of the crime.
And when you, I'm sorry.
Are you alleging he was prejudiced in his defense preparation?
Yes, he was. I think he was. Well, first of all, I think he was prejudiced because he wouldn't have had any understanding that he was going to be going to trial on count 8 based in part upon crimes for which he was never bound over. And I think that is prejudicial to the defendant. How is he supposed to know that when he's going to trial on count 8 through 12, is found guilty of count 8, that really he's actually facing charges on count 4, that he was not bound over
in his
on?
defense preparation, he was prejudiced, or during the trial he was prejudiced by this?
Well, I think he was, because of we're charging different forms of forgery in those two counts, and maybe, as I indicated, the prosecutor apparently had an understanding that one form of forgery had this as an essential element, the other form of forgery didn't. I think it's asking too much, and it's prejudicial to him to actually try to sort that out and prepare for trial if he's got an understanding that the elements of these two forms of forgery are different based upon the way that they've been charged.
And who has the burden to show that the defense preparation has been prejudiced?
I do. But I think that's showing that. I think that, again, a system which allows, well, let me say it this way. Just as the complaint is the jurisdictional document for the trial process, a notice of appeal is a jurisdictional document for the appellate process. And while notices of appeal are supposed to be construed liberally to meet the ends of justice, there are certain levels below which you can't go. If somebody goes to trial, goes to a jury trial, is contesting his innocence, and is found guilty, and he files a notice of appeal that doesn't appeal his conviction but merely appeals his sentence, he's stuck with that language. There's no liberal construction of it. And let's face it, most of the time, the appellants in these cases are the criminal defendants at trial. So I think there's a fundamental disconnect in the way these two situations are being handled, because prosecutors, based upon Hall, are given every advantage here. They're given the benefit of the doubt. If they don't draft these complaints correctly, then we're going to, in the absence of a motion to arrest judgment, we're going to liberally construe this. We're going to look at the four corners of the document. We're going to do everything we can to make sure that all the gaps of the missing elements are filled in somehow. We don't give criminal defendants filing notices of appeal that same lenience.
That's kind of a policy argument.
Well, I cut off Justice Rosen's question. I was going to go to him.
Oh, no,
I didn't know we'd
No,
domino
I just
effect.
want a point of clarification. What exactly happened to counts 1 through 7? Were they presented at the preliminary hearing, or was they amended complaint prior to preliminary hearing? What occurred? Do you know?
I don't recall. If you look at, I think it's like page 3 of the bench trial, which is volume 9. I know there the court makes a statement saying, I didn't bind the defendant over on counts 1 through 7.
And do we know if there was any evidence presented on those counts?
I
You just don't know.
I don't recall. I'd have
Okay.
to look at the record, Your Honor.
Okay, thank you.
Okay, I think it's my turn. When you're talking about the common sense reading and what you just described about the benefit of the doubt provided to the prosecution and filling gaps and what have you, that's the post-Hall standard. I understand you to be challenging its mere existence today, not just how it would be applied. Is that correct?
Right.
Okay, but I haven't heard that argument yet.
Well,
about why we should junk it.
Well, I think Hall is an aberration. Hall is, but for the existence of Hall, I think what would happen in these cases is there would be a finding that there is no jurisdiction. If a crime is absent essential elements, it is not a crime. It doesn't allege anything.
But Hall based that on the fact that a defective complaint really doesn't deprive the court of subject matter jurisdiction. It's more of a due process violation. And if that's the case, Hall actually helped the defendant, because if a defective complaint is merely a due process violation, then the failure to object at trial would waive that. Due process is waivable, whereas jurisdiction isn't. So that's the aberration in my mind. If Hall was saying this is merely a due process, then there shouldn't have been any remedy for defective complaint.
Well, I guess I would agree with it. I mean, I think this is a jurisdictional problem. And I think, but for Hall, the principles of law that would otherwise presumably apply would be ones that deal with the actual lack of jurisdiction. Now, Your Honor, in my experience, I haven't seen Hall as being a benefit to any of my clients, but I think it's something that needs to be reviewed, because I think there's an inconsistency there with the other body of jurisprudence that deals with these jurisdictional problems.
Counsel, can you prevail, can your client prevail in this case if the Hall rule is applied to construe the complaint liberally and in favor of validity? Are you making an argument that you prevail even applying Hall?
I think I could prevail even applying Hall, provided this court says you can't use crimes that the defendant isn't facing at trial, that have been kicked out at the probable cause stage. If you can't use those types of crimes and the language in those counts to supplement the missing parts of the crimes that the defendant is actually facing at trial. I'm out of time, so I'd entertain any other questions the court might have, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, my name is Stephen Jones. I am the Deputy Livette County Attorney. I represent the state. I don't plan on taking the full 15 minutes unless you'd like to ask me questions.
Well, I do. Mr. Jones, can you enlighten me as to what happened at preliminary hearing? Was there presentation on the first 7 charges, or did you just move to count 8 through 12, or do you know?
I can't really speak to the specifics. From my reading of the record, the charges were amended before the preliminary hearing to the way it is now. Evidence was presented, and the judge did not bind him over on those first 7.
And do you know why?
I don't. I wasn't there, and so I can't speak to that.
Okay.
I would say that the lodestar, the overriding principle of Hall was justice. Was that if the complaint was so defective that the defendant could not mount an argument, which is, I believe, what happened in Portillo, is that the defendant was blindsided by the request for an off-grid.
Can we look at the entire complaint, or are we limited to only the missing intent to defraud?
Excuse me. I believe if it was not brought up during the original charging, obviously Post Hall says that yes, you can, and I think you should in order.
Well, let's look at this then. I'm looking at both count 4 and count 8, and count 4 said the check was made, altered, or endorsed, that he did make, alter, or endorse a check, so it appeared to be made. He made a check, so it appeared to be made. And then count 8 says he issued a check, which he or she knew had been made, altered, or endorsed, so that it appeared to have been made. I don't understand how anyone would know what the crime is. You made a check, so it appeared to be made. I mean, the crime is it appeared to be made by someone else, but the charge didn't say that.
Correct, and I believe that during the preliminary hearing there was evidence that was put on. I understand that the charging document is defective. I don't believe that it's fatally defective given Post Hall, mainly because I believe that the defendant actually mounted a defense. He put evidence on that he had authority to write those checks, that he was given authority by the owner of those checks to write those, and so I don't understand how he can claim he didn't have the ability to mount a defense when he actually mounted a defense. Now, had he brought up that argument during the trial, I think that would have been a different story, and that would have been the pre-Hall.
So it's only Hall's rule in favor of liberal construction, in favor of validity, that saves the state's case. That's what saves the state's case here. Is that
correct? And I
saying?
believe that's what Hall said. He said the only reason we're dismissing count 2 is based purely on precedent, and we're about to change that because I believe the quote in Hall was, and they were quoting, I think, Fester, the United States Supreme Court, that said a challenge to the sufficiency of an indictment is not a game in which the lawyer with the sharpest eye or the cleverest argument can gain reversal for his client. I think that the principle of this is justice. If it was so unjust, which is what happened in Portillo, that the defendant couldn't mount an argument, it would be unjust if he couldn't make that argument why I shouldn't be on Jessica's law, then he shouldn't be held to that, which is not what happened in this case. The defendant was on notice. He knew during the preliminary hearing what he was being charged with. He knew during the trial what he was being charged with because he made a defense of that. And so I think that was what Hall was essentially trying to get to, is that you can't come afterwards, many years or many months afterwards, and say, oh yeah, there's an element that's missing, because justice is the overarching principle.
And I agree that that's a fair reading of what Hall tried to do, or the theory behind it, but Hall didn't overrule those prior cases that had said that a missing element, material element that's missing, creates a jurisdictional problem, did it?
I don't believe so, Your Honor.
In fact, it said, well, if you filed your motion to arrest judgment, then you get the benefit of the court looking at it as it had prior to Hall. And all of those cases said it's jurisdictional.
I believe so, correct.
So I mean, if it is jurisdictional, it's jurisdictional.
I guess I believe it was Hall that said that the jurisdiction just doesn't descend as soon as it's been amended. I think I can't answer that question, Your Honor. I apologize. My argument, and I believe the state's argument, is that Hall is a common sense application. Post Hall is a common sense application to these. If the charging document was so defective that it deprived the defendant of a fair trial, then it can be overturned.
And that would be a due process.
Correct.
Okay, and so how do we justify that with our jurisprudence that says a due process violation is waivable, and a failure to raise a due process issue at trial precludes raising that issue on appeal? But Hall says you can raise it for the first time on appeal. And you're going to use common sense, but you're raising the issue. You're not precluded from having the court consider the issue.
Well, because I think there are some instances, and I think Portillo is a perfect example of that. If it would have been solely bound by the post Hall, there's no way that Mr. Portillo could have received the relief that he was requesting. And I believe he was blindsided by that when the state, all intentions were that it was a level 1, and then its sentencing asked for an off-grid. There's no way that Mr. Portillo could have known that. Not in the document, not in the charging, not in the trial, not in the preliminary hearing. He never could have known that. And so I think in order for defendants to make that argument, they have to be left open to appeal it, which is what happened in Portillo. But I don't know that, I think what this court was trying to do in Hall was to cut down on the hyper-technicalities that were even talked about in jury trials, they were talked about in preliminary hearings. It was obvious by looking at the gentleman that he was over the age of 18 or whatever it may be. They were trying to cut down on those pure technicalities. I believe that the charging documents in most rape don't talk about they don't talk about penetration. It just references the statute. So you have to go to the statute and look and see what that is. And
Is it true that if a complaint is a jurisdictional document, that typically, at least, you wouldn't even get to these sort of common sense applications of what you described as technicalities? If it's a jurisdictional document, doesn't the court have to have jurisdiction before it can even apply these kinds of factors, common sense type factors?
Correct. And I think that that's something that Hall had to deal with. I mean, Hall had to deal with, and I think that, well, I don't pretend to know what Hall was thinking at the time or the court was thinking at the time. But that's an issue that has to be dealt with, obviously, but I don't know how to fix that problem. Because if you say it's jurisdictional and the court never has jurisdiction, if every point of that is not brought out specifically in the charging document, then I think justice suffers in many cases. Because it could be just a technicality. There could be a specific reason, a very simple reason why it wasn't put in. It was talked about. He was offered a fair trial, as was the case in Mr. Dunn, where he made the defense to these charges, and it was a technicality that these things were left out.
I'll just ask you the question. It may be an unfair question, but do you have a position here today as to whether or not a charging document is a jurisdictional document?
I don't have an answer to that, Your Honor. I apologize.
That's one way out of the thicket, is to say it's not.
A jurisdictional document?
Mm-hmm.
That
That it's a due process tool, but not a jurisdictional document.
And I haven't researched that in that situation, and I don't feel comfortable making an argument one way or the other. So if that's the question, I apologize that I don't have an adequate response to that.
Are you familiar with the U.S. Supreme Court decision, Cotton?
I am not, Your Honor. I apologize.
Well, I won't ask you to speculate then. All right. Any further presentation?
Not from the state, Your Honor.
Any more questions? Thank you, counsel.
Justice Rosen, try to answer your question. if you look at the preliminary hearing transcript, which is volume 2 at page 38, the court makes comments there about 09CR333, the case regarding the forgery. And basically what the court is saying is that count 8 is the only count of forgery that is supported by adequate evidence, particularly identification evidence. The other counts of forgery, apparently there wasn't anybody there to testify that the defendant was the actual person that passed these checks. And so there wasn't adequate proof for these other counts, and that's the basis as to why he was not bound over for trial.
Mr. Kittle, are you familiar with Cotton? It's
I'm
a
not yet.
2002 U.S. Supreme Court case. Okay.
Sorry.
But you probably are familiar with our case law that has applied Cotton, which is the Reyna and other lines of cases that have at least implied that the lack of an element in the complaint of age doesn't mean that the sentence is illegal. We have done that under both the Reyna line of cases, and we have done it under illegal sentences. We have said a sentence is not illegal even if the conviction is based on a defective complaint. In
Okay.
essence, that cannot be true if it's jurisdictional.
I would agree with that. The questions that were asked, all I can say is that in my experience, and I've probably made this comment to this court before, and I probably heard it made back to me by judges of the Court of Appeals in this court, that the complaint is the jurisdictional document for the trial process.
But is the allegation of elements part of that acquisition of jurisdiction? It is certainly the jurisdictional document to the extent it provides the subject matter jurisdiction of the court. It also, is a process that brings the defendant before the court for personal jurisdiction.
Right.
But is it necessary that every element be included in that for there to be jurisdiction? Isn't that really a notice issue and a due process issue, not a jurisdiction issue?
I don't know. I guess what's the alternative? If the allegations made in the counts don't provide jurisdiction or are not pertinent to the question of jurisdiction, then what actually does provide the jurisdiction to the court? I would think that in order for the court to have jurisdiction over the crime, there has to be an actual crime alleged, and that entails the language of the charging document and making sure that each of the elements is present.
Only because someone has said that. I mean, if you said count 1, violation of KSA 21, pick whatever crime you want.
Well,
that is enough to provide some level of notice of the charged crime, and arguably enough to give the court jurisdiction over the case and the defendant.
well,
But we have, through case law and statutes, gone further and said, this is the way you have to allege that.
yes.
But I'm not sure
Well, at a
whether
certain-
that deprives the court of jurisdiction if it fails in that specificity.
But at a certain level, Hall is just because that's what someone said.
And
Well,
everybody would admit we've just got several lines of cases that have not been reconciled. I
you
think.
can't reconcile. We've got a statute that says you can only be convicted of the charged crime or lesser, but in Reyna, we said, if we can find the evidence, then we can do it. And the Hall said, it's jurisdictional, but you can still appeal it. And so, what we've done and what we've said, we've actually allowed someone to be convicted of a crime that was not charged.
Right.
But then we've said that in order to have jurisdiction, you have to charge the crime. So I just don't think there's any reconciliation.
Yeah, I'm not sure that I can. I'm not sure the court is asking me to reconcile that. I don't know that I can. I can't. But I guess the ultimate point here is, and I don't have to tell the court this, but trial courts are vested with great powers. And it's important before the court act upon those powers that it has, that it make sure that it has the proper authority. There has to be some vehicle to give that court the proper authority. And I think regardless of these little, offshoots that come along in case law, I think the prevailing line of jurisprudence would indicate that the complaint is that document that confers jurisdiction on the trial court. And if there are problems with the complaint, if there are problems with the way those crimes are drafted, then that compromises the court's jurisdiction. I think that has been the understanding, at least for me, time out of mind, and that's why I think Hall is really an aberration to that, and I think that Hall needs to be re-examined by this court. At least that's what I would ask, with due respect.
Re-examination concluding what?
Concluding that the quote-unquote common sense approach of Hall is really not a common sense approach. That if there's language in Hall that basically says prosecutors in drafting charging documents need to have the statute book there beside them. Hall was a response to this court's frustration at having all of these issues before it, challenging the effectiveness of complaints. And while prosecutors are criticized in Hall, the effect of Hall is just to completely let prosecutors off the hook. Because they say, basically the result of Hall is if nobody complains about this during the trial process, then you're going to have to meet some higher standard of review, which is, virtually unmeetable. But none of that really talks to the question of jurisdiction. And I think that's what is at the heart of Hall and is kind of been overlooked in a way. And so I guess that's one of the things I would ask this court to reconsider based upon Hall.
Well, we know in jury instructions there are two different standards of review. If you objected at the trial court and did not, you have a higher standard. Is there any analogy here to be drawn?
Because the question of jurisdiction is something different. It's something that can't be waived. And so I guess I would argue that's the distinction between those 2 points.
Any further presentation?
No, Your Honor.
More questions? Thank you, counsel. Thank you both for your arguments this morning. We'll take this matter under advisement.